Hello friends and welcome to Gradeup. Hello everyone and welcome to Gradeup. Good afternoon friends. Good afternoon to all of you. So we start with this important series that we have started from Gradeup, which will intend to tell students that which are those important judgments, which are those important and crucial verdicts of the Supreme Court of India, which a student who is preparing for Clat 2020, AILET 2020, and a list of other examinations which are to be scheduled in 2020, they have to know all these things. So today we are going with part 3 of important judgments. Today we look at one of the very crucial judgments. One of the very crucial judgments of the Supreme Court, named Yashwant Sinha versus the CBI. Now what is this matter all about? The matter relates to whether a CBI inquiry should be made insofar as the procurement of the 36 Rafale air fighters are concerned. The Narendra Modi government entered into a contract, entered into an agreement with Rafale to buy Rafale 36 fighter jets. Okay, now the Supreme Court was called upon because there was a lot of hue and cry by the opposition saying that the deal by the Narendra Modi government was filled with scams. It was a scam. Now, Yashwant Sinha, a former minister of the Vajpayee government, Arun Shourie, another great personality in India, as well as Prashant Bhushan, a senior lawyer in the Supreme Court, approached the Supreme Court on the forefront that the procurement, that the buying of these advanced jet, that is called the Rafale jets, to modernize India's air force was a big scam. Am I clear, friends? So understand this, friends. This was a case wherein the Supreme Court was approached by some people like Yashwant Sinha, Arun Shourie, and Prashant Bhushan, asking that the court directs the CBI to file a FIR against this deal. Now, this Rafale deal, let me tell you first what is this Rafale deal. The Rafale deal, as you see in your screen, is a deal between India and France for procurement of advance. Please try to understand this, friends. This was a deal for buying advanced jet fighters as part of modernization. Please keep this in your mind, friends. Okay, this was a deal to buy certain 36 Rafale jets. Am I clear? Yashwant Sinha, Aman Singh says, who is Yashwant Sinha? Yashwant Sinha happens to be a former minister of the NDA-1 government, that is the Vajpayee government. I'm not talking about the Modi government, the Atal Bihari Vajpayee government. Okay. Yeah, Deepak Patel, Justice Bobde is the present Chief Justice of India. But before Justice Bobde became the Chief Justice of India, Justice Ranjan Gogoi was the Chief Justice. Keep this in your mind, friends. Okay. So before Justice Bobde assumed the chair of the Chief Justice of India, Justice Ranjan Gogoi was the Chief Justice of India. So this was a very important judgment that was given under the regime of Chief Justice Ranjan Gogoi. Justice Ranjan Gogoi, Justice Sanjay Kishan Kaul and Justice K.M. Joseph were the three judges who decided on this case. Now, let's understand the case. Now, the Rafale deal was a government-to-government agreement. It was a government-to-government agreement between India and France to buy 36 on a fly-away condition. It's given over here, friends, okay? It's a fly-away condition, okay? Please understand this. So, 36 Rafale jets were to be bought by India from France on a fly-away condition. The procurement of these advanced jet fighters were a part of modernizing the Indian Air Force. Yeah, okay. Yeah, Ranjan Gogoi has been nominated for Rajya Sabha. Correct, correct. Is it Dassault Aviation? Absolutely correct. Absolutely. Rakesh Kumar. Fantastic. Now, after the Modi government came into power in 2014, the government, which was headed by Modi, entered into an agreement with France to buy a 36 jet fighters on a fly-away condition. Am I clear? And this was announced when Prime Minister Narendra Modi visited France. Now, it was a multi-crore deal. This was a multi-crore deal. Someone says, there are a lot of people who says 56,000 crore deal. Someone says 80,000 crore deal. We don't know the numbers, the real figures. But the opposition inside the parliament shouted and claimed that it was a scam. Please understand this. The opposition, the Congress government, the Congress people as well as the entire opposition shouted against the government and said that it was a scam. Now, whether it was a scam or not a scam, what they did is that Yashwant Sinha, Arun Shourie and Prashant Bhushan filed a petition before the Supreme Court and asked the Supreme Court for a direction to the Central Bureau of Investigation to file an FIR insofar as this deal is concerned and to see whether there was any irregularity concerned. Am I clear? Now, before we go ahead and see what was the arguments, now let me tell you that at Gradeup we have come up with a Target Law 2020, a Scoreup course where we are going to provide you with 100 plus live classes, interactive quizzes, 3,000 plus practice question, 12 mocks, topic-wise quizzes, PDFs for revision, and a full coverage of current affairs and legal knowledge. Those of you who are interested for this crash course, please go to the description and you will find a link whereby you can directly enroll yourself for this Target Law 2020, a Scoreup course which is organized by Gradeup. Okay. Now let's go ahead. What was the issue? What was the issue? The issue before the Supreme Court was whether the CBI, an Indian premier investigative agency, should register a FIR insofar as this Rafale deal is concerned. The question before the Supreme Court was whether the CBI should register a first information report insofar as this Rafale deal is concerned. And the second question was whether there are grounds to order an FIR into the allegations of irregularity into this controversial Rafale deal. Am I clear, friends? So there were two very important questions that was raised before the Supreme Court. Number one was whether the CBI should file a FIR insofar as this procurement deal is concerned of 36 fighter jets. And the second question was whether there are grounds to order FIR insofar as this Rafale deal is concerned. Am I clear? These were the two important issues before the court. Now let's move into the arguments. Yashwant Sinha, Arun Shourie and Prashant Bhushan, they argued, they produced certain documents. They produced certain documents which were either stolen or leaked or photocopied. They did not get all these documents. Now they produced certain documents to show, that the deal was a scam. How did they show? They got certain documents from the ministry, from the government of India, which were either stolen, either leaked, or were they photocopied. Now the question was, and they said that they had a right to information. Yeah, it's nothing stolen. It's information with the government, and under the RTI Act, that is the Right to Information Act, they had the right to get this information. Now, the admissibility of these leaked or these stolen documents was a contention before the court. Now, if certain documents, now understand this, friends, if a document is stolen from the government of India's office, can it be produced in a court to lay forth an argument to direct the CBI to file an FIR? The question is this. The question is whether a document which is purportedly either stolen or leaked or photocopied can be used by a petitioner before the Supreme Court to advance his argument that the CBI should inquire into the irregularities. Am I clear, friends? Did you understand? Am I clear? Am I clear, friends? So, understand the fact that there was an argument by the petitioner, that is these three people, Arun Shourie, Yashwant Sinha, as well as Prashant Bhushan, saying that these documents goes on to show that there were certain irregularities. Now, what did the government of India say? The government of India, whether the CBI or the Union of India, said that the documents that are relied by the petitioners, that is Yashwant Sinha and group, are either stolen or leaked, and thus they are not admissible in a court. Am I clear? Understand this. And prior to these case being lodged in the Supreme Court, there was an article in the Hindu which published all these documents, these stolen documents. Now, Union of India said that the article that was published in the Hindu, which are based on these stolen or these leaked or these photocopied documents, are a violation of the Official Secret Act of 1923. The argument of the CBI was that these documents that are put forth before the court were stolen, leaked or photocopied, and thus are violative of the Official Secret Act. The Union of India said that, look, there is a security of the country is concerned. Now, buying a jet, what is the price of the jet, what are those things that are involved inside the jet, should it come under the Right to Information Act? Now, suppose India is buying a Rafale jet. Now, suppose that jet cost X amount of money. Should India tell everybody at large what is the cost of the jet? Because there are neighboring countries like China and Pakistan, they will come to know how good is the jet and how bad is the jet. They will come to know by the pricing itself whether the jet has modern technology, whether it has missiles fitted on it or not. Now, when a government is buying, when government buys these jets or these arms and ammunition for the security and safety of India, should the pricing be given to everyone? Should the government tell what is the price of a jet to each and every one? Now, the government said that if we say all these things, that will undermine the security of the country. And remember, the security and of the country is paramount in nature. The security of the country is paramount in nature. Am I clear, friends? Did you understand what I'm trying to say? Okay. So, the Hindu published a document. The government of India says that it's a violation of the Official Secrets Act. Thereafter, the government says that we will not tell the petitioners what is the price of these jets, because Pakistan, China and other enemy countries will come to know about the pricing of the jet, and they will understand what is inside the jet and how good that jet is. Am I clear? Okay, friends. So this is a startup, a Scoreup course that we have launched. Those of you who are interested may finally go to the description and directly join the course, friends. Up next, what did the Supreme Court do? The Supreme Court directed the center. Now, very important, friends. Okay, number one, the Supreme Court directed the center that they file in a seal cover without telling the petitioners the details of the agreement buying those 36 fighter jets. The Supreme Court said that, okay, if the government of India does not want to disclose the pricing to everyone, then very good, give in a seal cover to the judges. So the Supreme Court directed the center to file the agreements for buying this 36 Rafale jets. Number one. Secondly, what did the Supreme Court direct? The Supreme Court further directed that the center should provide details insofar as the decision making of this Rafale fighter jet deal is concerned, and that too in a seal cover. Again, the Supreme Court directed the center that they file in a seal cover the details of the decision-making process. How did the center decide and finalize on buying Rafale and not any other jet? Am I clear? Thirdly, the Supreme Court directed Kajal Jatishwar says paramount means important. It's supreme. Paramount means supreme. Okay. Paramount means supreme. Yeah. And number three, the Supreme Court directed the central government to again file in a seal cover the pricing details of these 36 Rafale jets. Please keep this in your mind, friends. Okay. So the Supreme Court directed the union to file in a seal cover the pricing details. That, okay, if you do not want to tell the pricing of these Rafale jets to everyone, okay, but tell it to us, tell it to the court. That is what the Supreme Court judges said. Am I clear, friends? Did you understand? Now let's understand the Supreme Court's judgment. The Supreme Court said that even after an assumption that these documents were not procured in a proper manner, that means they were either leaked, either stolen or photocopied, should a court be shut out of considering these documents? And the Supreme Court said, no, we can consider these documents even if they are stolen, if they are leaked or if they are photocopied. Am I clear, friends? Did you understand? The Supreme Court said that even if these documents are either stolen, photocopied or leaked, they cannot be shut out of the court's consideration. Am I clear? Did you understand? Am I clear? Number two, the Supreme Court said that there is no law enacted by the Parliament that bars prohibition on the publication of these documents, because you know the Hindu published an article based on these leaked documents. Am I clear? And henceforth the Supreme Court said that freedom of press is also paramount. It is embedded under Article 19(1)(a), freedom of speech and expression. Am I clear? So Article 19(1)(a), freedom of speech and expression, comes into being. Freedom of the press. The press has the freedom to come with any article of its choice. The government tomorrow cannot stop the press or the news agency from asking them that you publish one document and you do not publish this document. Can the government say that? The answer is no. So that means the Supreme Court upheld the freedom of speech and expression, which is guaranteed under Article 19(1)(a) of the Constitution. The Supreme Court upheld the freedom of the press under this judgment. Am I clear? So Supreme Court said that even if these documents are either stolen or leaked, court cannot be shut out from considering. Am I clear? Secondly, the Supreme Court said that there is no law which is enacted by the Parliament which prohibits publication of these documents, thereby upholding freedom of press. Thirdly, the Supreme Court said that there is no provision under the Official Secret Act, keep this in your mind, that restrains publication of documents marked as secret. Even the Official Secret Act is silent about it. Now, if there is a loophole in the law, should the union say that this is just a loophole in the law? No. Understand this, there is no provision under the Official Secret Act which restrains or prohibits the publication of a document which is marked as secret from placing it before the court. Now, the Supreme Court also agreed that there is a tussle or a fight between Right to Information Act and Official Secret Act. The Supreme Court came to a conclusion, yes, there is this Right to Information Act in one hand and Official Secret Act in the other. Now, Official Secret Act is an act that is enacted to protect or to make secrecy insofar as highly secret documents are concerned. Like, suppose there is a deal between India and some other country insofar as buying jet fighters are concerned. Now, they come under the Official Secret Act because these are highly secretive documents. Okay. Everybody should not come to know what is the deal between India and France insofar as procurement of 36 Rafale jets are concerned. Am I clear? So there is always a tussle between the two. But the Supreme Court has to adjudicate a matter, has to decide upon a matter based on the law. There is no provision inside the Official Secret Act that prohibits that a document that is marked as secret that cannot be placed before the court. It can be placed before the court, and that's the reason Supreme Court directed that, asked the government of India to file in secret, in sealed cover. That is, in sealed cover. That means nobody else would be able to see other than the three judges who decided the case. Justice Ranjan Gogoi, Justice Sanjay Kishan Kaul, and Justice K.M. Joseph. Am I clear? Only these three judges will be able to see. They want to see, am I clear, whether the government, whether there was a scam or not a scam. The Supreme Court said, and finally this is the judgment. The Supreme Court finally held that there is no occasion to doubt the decision making of the government of India insofar as the Rafale deal is concerned. And thereby, the Supreme Court dismissed all the petitions seeking direction to the CBI to file a FIR insofar as the alleged irregularities is concerned. Am I clear? Okay. Someone has asked me, sir, what will happen if media leaks this document? See, even if media leaks this document, can the Supreme Court shut its eye and say that we are not going to look into these documents just because they are leaked or they are photocopied or they are not procured under proper manner? The Supreme Court said no. Even if they are stolen, even if these documents have been leaked, the Supreme Court is not precluded, is not thrown away from, is not shut out from looking into these documents. Am I clear? Okay, please understand this. Court of law means a court of justice. The High Court, the Supreme Court, trial courts are all court of law. They decide on law, and that's why the courts are called court of law. Okay, Nakul, this was an answer to you. So the Supreme Court said finally that there was no occasion, to doubt the decision-making process of the government of India insofar as the Rafale deal is concerned. And the Supreme Court dismissed all the petitions that were seeking a direction from the court to the CBI to register an FIR against the irregularities. Am I clear? Henceforth, the Supreme Court gave a clean chit to the government of India insofar as the purchase or the procurement of the 36 Rafale fighter jets are concerned. The Supreme Court said that there was no scam. Am I clear, friends? The Supreme Court finally said that there were no scams. Am I clear? Now, so with this, we have come to we did understand a very, very important judgment of the Supreme Court. The judgment's name is Yashwant Sinha versus the CBI, whereby the Supreme Court upheld under Article 19(1)(a) the freedom of press, the freedom of speech and expression, and has also held that the government has declared that there was no scam involved in the Rafale jet deal is concerned. So insofar as the Rafale jet deal is concerned, there was no scam. That is what the Supreme Court held. Am I clear? Did you guys understand this? Okay. So we at Gradeup has launched a Target Law 2020, a Scoreup course for all of you who are preparing for Clat as well as other law entrance examination. These are all YouTube classes where we are taking short classes for you to prepare for this examination. Now, these judgments will be taught in details in the course. These judgments will be taught in details in the course. Am I clear? Am I clear? So these judgments that you are seeing, that are being discussed today, will be taught in details in the crash course. So those of you who are interested in this course may just go to the description box and buy the course. Am I clear? We have already started with the course. It is a very, very helpful course for all of you who are preparing for Clat and other law entrance examination for the year 2020. With this, we come to the end of today's class. Stay home, stay safe, prep smart, score better. Thank you very, very much. God bless you. In case you guys have any doubts insofar as today's class is concerned, after the video is over, Please put down all your doubts in the comment section so that we can reply to you. Thank you very, very much. God bless you. Thank you.